Good morning. This is in Suraj Singh, International Professional Engineer. A talk on management contracts, 26th April 2020. Professional talk, quality management, quality system, documentation, projects, and general. This is certificate of chartered engineer. I'll talk about this later on because these are also important. Now I'm going to discuss about management, which includes contracts, because this management is inclined on contracts. If there are no contracts, there are no management. We relate our profession to contracts, all contracts, everywhere contracts. Contract must be understood very well. Every country has a law that is called Contract Act. In our country also there is a law which was enacted by our Parliament, British Parliament, 1857, Indian Contracts Act that is called. I will not take much time, just go on to that directly. And this is Indian Contract Act 1872. I had started yesterday about this. I had talked something. Now Indian Contract Act 1872, which was Act number 9 of 1872, 25th April 1872. Its preamble, whereas it's expedient to define and amend certain parts of law relating to conduct, it's hereby enacted as follows. And preliminary is, what is preliminary? Let's see first of all. Short title. Short title, this act may be called Indian Contracts Act 1872, and it extends the whole of India at that time except state and geography. Well, that's all normal. Now, nothing herein shall affect provisions of any statute, act or regulation, not hereby expressly repealed, nor any uses or custom of trade, nor any incident of any contract, not inconsistent with provisions of this act, with general language written where. Now, interpretation of clauses. The interpretation of clauses in this act, following words and expressions are used in following senses unless a contrary intention appears from context. It is A. When one person signifies to another his willingness to do or to abstain from doing anything with a view to obtaining assent of that other to such act or abstinence, he is said to make a proposal. This is a definition of a proposal, I repeat. When one person signifies to another person willingness to do or to abstain from doing anything with a view to obtaining assent of that other person to such act or abstinence, that is said to make a proposal. So this is definition of proposal. B. When person to whom proposal is made signifies his assent thereto, proposal is said to be accepted. A proposal, when accepted, becomes a promise. So there are two words here, two terms here. One is proposal and other one is promise. Proposal, one person submits to something, offers to someone its proposal, and when it's accepted by other one, it's called promises, means one is accepted. So proposal and promise, two are here. Once again I read for your clear understanding. When one person signifies to another person willingness to do or to abstain from doing anything with a view to obtaining assent of that other person to such act or abstinence, he is said to make a proposal. This is definition of proposal. And what is definition of promise? When person to whom proposal is made signifies his assent thereto, proposal is said to be accepted, and proposal when accepted is named, is called, or becomes promise. So proposal and promise, these are two definitions, original definitions. Person making proposal is called promisor, Person making proposal is called promiser, and person accepting proposal is called promisee. So promiser and promisor, this is a very original definition, promiser and promisee. When at desire, when at desire of promiser, promisee or any other person has clung or abstained from doing, or does or abstains from doing, or promises to do so, or to abstain from doing something, such act or abstinence of promisee is called a consideration for promise. So this is consideration. So what is that? Proposal, promise, proposal, promise and consideration. These are three words. You have to understand that. Proposal, promise, consider. Proposal means I make proposal to you. Okay, that's proposal. You accept that, it becomes promise. And then there is something in exchange of that is transacted or to be transacted, that is consideration. Now let's move further. Now chapters and sections of this Transfer of Property Act, whatever it is, which standards and conduct are in place of which that act in force to be taken as part of this act. See Act Article Act of 4 of 1882. It says chapter and sections of Transfer of Property Act 1882, 4 of 1882, which relate to contracts are in places in which that act is in force to be taken as part of this act. See Act number 4 of 1882. Now come on to it has been amended in all right. I'll go to now another one, and that is words. The words enactment mentioned in this schedule hereto are repealed, extent specified in third column, etc. That also is all there. Now let's go to it's real. Now it says that every promise and every set of promises forming consideration for each other is an agreement. Every promise and every set of promises, every promise or every set of promises forming consideration for each other is an agreement. Promises, first was proposal, then was promise, and then was consideration. So promises which form consideration or part of consideration for each other are called reciprocal promises. An agreement not enforceable by law is said to be void. Whatever agreement is there, if it's illegal or law cannot take care of that, it's against law, it's void agreement. Now agreement enforceable by law is contract. So what is contract? Agreement between two parties or whatever that can be enforced by law is contract. An agreement which is enforceable by law at option of one or more of parties thereto, but not at option of other or others, is a voidable contract. So one is contract, one is voidable contract. When one party only likes it to be enforced, other doesn't, it's voidable contract. That contract can be declared void. A contract which ceases to be enforceable by law becomes void when it ceases to be enforceable. Now we are going to chapter 1. Actually now yesterday certain definitions I tried to explain you. Yesterday I started that and I covered that one. So now chapter 1 is communication, acceptance and revocation of proposal. Let's see how it works. Now communication, acceptance and revocation of proposal. What is communication, acceptance, revocation? Actually communication, acceptance and revocation of proposals. Communication of proposal, acceptance of proposal and revocation of proposals and acceptance respectively are deemed to be made by any act or omission of party proposing, accepting or revoking, by which intends to communicate such proposal, accepting or revocation, or which has effect of communication. Now communication when complete. When is communication complete? Communication when complete. Communication of proposal is complete when it comes to knowledge of person to whom it is made. Communication of a proposal is complete when this communication comes to person, to knowledge of person to whom it is made. Communication of an acceptance is complete as against proposer when it is put in a course of transmission to him so as to be out of power of acceptor. as against acceptor when it comes to knowledge of proposer. Now, if you have communication, then communication of a revocation is complete against person who makes it. Communication of revocation as against the person who makes it when it is put into a course of transmission to person to whom it is made, so as to be out of power of person who makes it. Now, as against person to whom it is made when it comes to his knowledge. Now, let us illustrate this. A proposes by letter to sell a house to B. A proposes to sell a house to B at certain price. Communication of proposal is complete when B receives letter. Now B accepts A's proposal. Letter is posted as against B. When letter is received by A revokes this proposal by telegram. Alright. Revocation is complete as against A when telegram is dispatched. It is complete as against B when B receives it. Well, B revokes his acceptance by telegram. B's revocation is complete as against B when telegram is dispatched, and against A when it is. Alright, this is just now we'll go through what actually we want to say. There are so many in this. Now we will go to how to do it. Names. Actually, there are so many provisions in this, and like that I would like to name them first of all, and that so that we understand which one we have to discuss and which one we have to discuss. All cannot discuss. Revocation of proposal and acceptance. Its definition of revocation of proposals and acceptance. A proposal may be revoked at any time before communication of its acceptance is complete as against proposer, but not afterwards. So revocation of proposals and acceptance. A proposal may be revoked any time before communication of its acceptance is complete as against proposer, but not afterwards. An acceptance may be revoked at any time before communication of acceptance is complete as against acceptor, but not afterwards. Now let's go to revocation how made. Revocation how made. A proposal is revoked by communication of notice of revocation by proposer to other party by lapse of time prescribed in such proposal for its acceptance, or if no time is so prescribed, by lapse of a reasonable time without communication of acceptance. By failure of acceptance to fulfill a condition precedent to acceptance, by death or insanity of proposer, if fact or his death or insanity comes to knowledge of acceptor before acceptance. Now, acceptance must be absolute. Acceptance must be absolute in order to convert a proposal into a promise. In order to convert a proposal into promise, acceptance must be absolute. So acceptance must be absolute and unqualified, and be expressed in some usual and reasonable manner, unless proposal prescribes manner in which it is to be accepted. If proposal prescribes a manner in which it is to be accepted and acceptance is not made in such manner, proposer may within a reasonable time after acceptance is communicated to him insist that his proposal shall be accepted in prescribed manner and not otherwise, but if he fails to do so, accepts acceptance. Now acceptance by performing conditions or receiving considerations. Acceptance by performing conditions or receiving considerations. Performance of conditions of a proposal or acceptance of any consideration for a reciprocal promise which may be offered with a proposal is accepted by proposal. Acceptance of proposal. Promises express and implied. Promises express and implied insofar as proposal or acceptance of any promise is made in words. Promise is said to be express insofar as such proposal or acceptance is made otherwise than in words. Promise is said to be implied. So there are two meanings here. Promise is express or implied. Express means promise. Express is express and implied insofar as proposal or acceptance of any promise is made in words. Promise is said to be express insofar as such proposal or acceptance is made otherwise than in words. Promise is said to be implied. Now, chapter 2, that is of contracts, voidable contracts and void agreements. This is chapter 2, contracts, voidable contracts and void agreements. What agreements and contracts actually? We have already talked, let me repeat it. What agreements are contracts? All agreements are contracts if they are made by free consent of parties competent to contract for a lawful consideration and with a lawful object, and are not hereby expressly declared to be void. Let me repeat. What agreements are contracts? This is defined as all agreements are contracts if they are made by free consent of parties competent to contract for a lawful consideration and with a lawful object, and are not hereby expressly declared to be void. Nothing herein contained shall affect any law in force in our country or in India or whatever, and not hereby expressly repealed, by which any contract is required to be made in writing or in presence of witnesses, or any law relating to registration of documents. Who are competent to contract? That's a question. Who are competent to contract? Who are competent to contract? This is Article 11. Every person is competent to contract who is of age of majority according to law to which he is subject, and who is of sound mind and is not disqualified from contracting by any law to which he is subject. I repeat, who are competent to contract? Every person is competent to contract who is of age of majority according to law to which he is subject, and who is of sound mind and is not disqualified from contracting by law, by any law to which he is subject. Now, let's go further. What is the 12? What's Article 12? What is a sound mind for purpose of contracting? This is Article 12. What is sound mind for purpose of contracting? A person is said to be of sound mind for purpose of making a contract if at time when he makes it he is capable of understanding it and of forming a rational judgment as to its effect upon his interests. Repeat, what is a sound mind for purposes of contracting? A person is said to be of sound mind for purpose of making a contract if at time when he makes it he is capable of understanding it and of forming a rational judgment as to its effect upon his interests. Now a person who is usually of unsound mind but occasionally of sound mind may make a contract when he is of sound mind, and a person who is usually of sound mind but occasionally of unsound mind may not make a contract when he is of unsound mind. Come on, next one. What is Article 13? Consent defined. Consent defined. Two or more persons are said to consent when they agree upon same thing in same sense. Two or more persons are said to consent when they agree upon same thing in same sense. What is free consent? Article 14 defined. A free consent defined. Consent is said to be free when it is not caused by. Free consent is defined is consent is said to be free when it is not caused by coercion. as defined in section 5, or undue influence as defined in section 16, or fraud as defined in section 17, or misrepresentation as defined in section 18, or mistake subject to provisions of section 20, 21 and 22. So what are points here? Free consent is said to be free when it is not caused by, means these are qualifications, these should not apply, means free consent means minus this, but says free consent means consent is said to be free when it is not caused by coercion as defined in section whatever. Coercion, there should be no coercion, there should be no undue influence, there should be no fraud, there should be no misrepresentation, there should be no mistake. Again, there should be no coercion, there should be no undue influence, there should be no fraud, there should be no misrepresentation, there should be no mistake. So free consent means absence of coercion, absence of undue influence, absence of fraud, absence of misrepresentation, absence of mistake. We'll read them later on, we'll understand later on. Now, consent is said to be so caused when it could not have been given but for existence of such coercion, undue influence, fraud, misrepresentation or mistake. Now let's go to coercion defined. What is coercion? That's 15, article 15 defined. It is coercion is committing or threatening to commit, any act forbidden by Indian Penal Code. Coercion is committing or threatening to commit certain act forbidden by Indian Penal Code, or unlawful detaining or threatening to detain property or to prejudice of person whatever, with intention of causing any person to enter into an agreement. Again, coercion is committing or threatening to commit certain act forbidden by Indian Penal Code, or unlawful detaining or threatening to detain certain property to prejudice of certain person whatever, with intention of causing certain person to enter into an agreement. This says, now explanation is it's immaterial whether Indian Penal Code is or is not in force in place where coercion is employed. Now let's go to what is 24. Sorry, not 24. This is let's go to item 16. Undue influence defined. This was previous was coercion. We learnt in that article 15 coercion. Now we learn what is undue influence in article 16. Undue influence. A contract is said to be induced by undue influence when relations subsisting between parties are such that one of parties is in a position to dominate will of other and uses that position to obtain an unfair advantage over other. Let me repeat. A contract is said to be induced by undue influence where relations subsisting between parties are such that one of parties is in a position to dominate will of other and uses that position to obtain an unfair advantage over other. In particular and without prejudice to generality of foregoing principles, a person is deemed to be in a position to dominate will of another where he holds a real or apparent authority over other, or where he stands in a fiduciary relation to other, or where he makes a contract with a person whose mental capacity is temporarily or permanently affected by reason of age, illness or mental or bodily distress. Now, where a person who is in a position to dominate will or another will of another, enters into a contract with him, and transaction appears on face of it, or on evidence adduced to be unconscionable burden of proving that such contract was not induced by undue influence shall lie upon person in a position to dominate will of other. I repeat, this very important and very complicated as well. It says, where a person who is in a position to dominate will of another, where a person who is in a position to dominate will of another enters into a contract with that person, and transaction appears on face of it or on evidence adduced to be unconscionable burden of proving that such contract was not induced by undue influence shall lie upon person in a position to dominate will of other. Nothing in this subsection shall affect provision of section 3 of Indian Evidence Act. Now come on, let's go to someone else, and I'm not going to give an example here. Article 17, fraud defined. What is fraud? Fraud definition is, fraud means and includes any certain of following acts, committed by a party to a contract or with his connivance or by his agent. Fraud means and includes any of following acts committed by a party to a contract or with connivance or by his agent, and it is like that here, with intent to deceive another party thereto of his agent or to induce him to enter into contract. What are that? Suggestion as a fact of that which is not true. Suggestion as a fact of that which is not true, but one who does not believe it to be true. So what's that? Suggestion as a fact of that which is not true by one who does not believe it to be true. Next is active concealment. Active concealment of a fact by one having knowledge or belief of fact. Promise made without any intention of performing it. Promise made without any intention of performing it. Any other act fitted to deceive. Any such act or omission as law especially declares to be fraudulent. So these are, you can say about, this is definition of fraud. Fraud is based on following, means fraud means includes any of following acts, which are following acts I explained, committed by party to a contract or with his connivance or by his agent, and these are with intent to deceive another party with thereto of his agent or to induce him to enter into contract. Number one, that is suggestion as a fact. Suggestion as a fact of that which is not true, but by one who does not believe it to be true. Active concealment of a fact by one having knowledge or belief of fact. Promise made without any intention of performing it. Any other act fitted to deceive. Any such act of omission as law especially declares to be fraudulent. Now let's go to, just as an explanation, let me speak. Mere silence as to facts likely to affect willingness of a person to enter into a contract is not fraud. What it says, let us explain. It says that mere silence of a person, mere silence as to facts unlikely to affect the willingness of a person to enter into contract is not fraud, unless circumstances of case are such that regard being had to them. It's duty of person keeping silence to speak, or unless his silence is in itself equivalent to speech. Oh, come on now, we'll say what is 18 misrepresentation. What is misrepresentation? Misrepresentation means includes as follows. Positive assertion. Misrepresentation is positive assertion in a manner not warranted by information of person making it. Positive assertion in a manner not warranted by information of person making it of that which is not true, though he believes it to be true, and any breach of duty which without an intent to deceive gains an advantage to person committing it, or anyone claiming under him by misleading another to his prejudice or to prejudice of anyone claiming under him, causing, however innocently, a party to an agreement to make a mistake as to substance of thing which is subject of agreement. So I'll repeat this three. Article 18 is misrepresentation, which defines as positive assertion in a manner not warranted by information of person. Positive assertion in a manner not warranted by information of person making it of that which is not true, though believes it to be true. Any breach of duty which without an intent to deceive gains an advantage to person committing it, or anyone claiming under him by misleading another to his prejudice or to prejudice of anyone claiming under him, causing, however innocently, a party to an agreement to make a mistake as to substance of thing which is subject of agreement. These points are misrepresentation. Misrepresentation is where this is not on contract, there should be no misrepresentation. So come on to next one, that now says wide ability of agreement with free consent. Wide ability of agreements with free consent, and wide ability, this is Article 19. Wide ability of agreements without free consent. When consent to an agreement is caused by coercion, fraud or misrepresentation. We have all discussed this. Number one was coercion, we discussed fraud and misrepresentation just now. So it says that when consent to an agreement is caused by when consent to an agreement is caused by coercion, fraud or misrepresentation, agreement is a contract voidable at option of party whose consent was so caused. So now, a party to a contract whose consent was caused by fraud or misrepresentation may, if he thinks fit, insist that contract shall be performed and that shall be put in position in which he would have been if representations made had been true. Now, exception is, there's an exception. If such consent was caused by misrepresentation or by silence, fraudulent within meaning of section 17, contract nevertheless is not voidable if party whose consent was so caused had means of discovering truth with ordinary diligence. Now we go to another one. I'm not going to illustrations because this will lay off time. So it's now this 19A, which is power to set aside contract induced by undue influence when consent to an agreement is caused by undue influence. Agreement is a contract voidable at option of party whose consent was so caused. This is next 19A, and this is only the power to set aside contract induced by undue influence when consent to an agreement is caused by undue influence. Agreement is a contract voidable at option of party whose consent was so caused. Any such contract may be set aside either absolutely or if party who was entitled to avoid it has received any benefit thereunder upon such terms and conditions as to court may seem just. Now we are going to another clause, and I'm not going through all these explanations given this. Now 20, Article 20, agreement void where both parties are under mistake as to matter of fact. So it says where both parties to an agreement are under a mistake as to a matter of fact essential to agreement is void. Its explanation is an erroneous opinion as to value of thing which forms subject matter of agreement is not to be deemed a mistake as to a matter of fact. Now let's go to other one, effect of mistake as to law, Article 21. Effect of mistakes as to law. A contract is not voidable because it was caused by a mistake as to any law in force in India, but a mistake as to a law not in force in India has the same effect as mistake of fact. Let's go to Article 22. Contract caused by mistake of one party as to matter of fact. Contract caused by mistake of one party is as to matter of fact. A contract is not voidable merely because it was caused by one of parties to it being under a mistake or as to matter of fact. Now here is some insertion here. I'm not concerned with that. Leave that one alone. Now Article 23. What considerations and objects are not? This is what considerations and objects are lawful and what not. Consideration or object of an agreement is lawful unless it is forbidden by law. Every object on an agreement is lawful, consideration or object is lawful unless it is forbidden by law, means law does not permit it, is of such a nature that if permitted it would defeat provision of any law, or is fraudulent, or it involves or implies injury to person or property of another, or court regards it as immoral or opposed to public policy. So what are points there for which contract cannot be accepted? Is forbidden by law. Whatever object there is or whatever consideration there is, it is forbidden by law. Law doesn't accept it, or is of such a nature that if it is permitted, it would defeat provisions of law, or it is fraudulent, or it involves or implies injury to person or property of another one. A court regards it as immoral or opposed to public policy. In each of these cases, consideration or object of an agreement is said to be unlawful. Every agreement of which object or consideration is unlawful is void. It means it doesn't work. It has no meaning. This is no contract. That means that. Now we'll go to. I'm not going to explanations because that will just waste of time. So I'll just jump over to Article 24. That's agreement. Agreement void. Agreement void if considerations and objects unlawful. It says agreement void, Article 24, if consideration and objects unlawful in part, if any part of single consideration for one or more objects, or any one or any part of any one of several considerations for a single object is unlawful, the agreement is void. Alright then. Article 25, it says agreement without consideration void. Agreement without consideration, unless it is in writing and registered, or is a promise to compensate for something done, or is a promise to pay a debt barred by limitation law. It says agreement without consideration void unless it is in writing unless it is in writing and registered, or is a promise to compensate for something done, or is a promise to pay a debt barred by limitation law. An agreement made without consideration is void unless it is expressed in writing and registered under law for time being, in force for registration of documents, and is made on account of natural love and affection between parties standing in a near relation to each other. What is said, let me repeat this. It says, it's very important here. An agreement made without consideration is void unless it is expressed in writing and is registered under law for time being, in force for registration of documents, and is made on account of natural love and affection between parties standing in a near relation to each other, or unless it is a promise to compensate wholly or in part a person who has already voluntarily done something for promisor, or something which promisor was legally compellable to do so, or unless it is a promise made in writing and signed by a person to be charged therewith, or by his agent generally or specially authorized in that behalf, to pay wholly or in part a debt of which creditor might have enforced payment but for law for limitation of suits. In any of these cases, such an agreement is a contract. Now, let's go to another one, and I will not go to explanations, no need, no meaning. Article 26, agreement in restraint of marriage void. Agreement in restraint of marriage void. Let me see that. Agreement in restraint of marriage is void. Every agreement in restraint of marriage of any person other than a minor is void. Agreement, Article 27, agreement in restraint of trade void. Agreement in restraint of trade void. Every agreement by which anyone is restrained from exercising a lawful profession, trade or business of any kind is to that extent void. Saving of agreement not to carry on business of which goodwill is sold, saving of agreement not to carry on business of which goodwill is sold, exception one who sells goodwill of a business may agree with buyer to refrain from carrying on a similar business within specified local limits, so long as buyer or any person deriving title to goodwill from him carries on a like business therein, provided that such limits appear to quote reasonable regarding being had to nature of business. I repeat this one. It says agreement in restraint of trade void. Every agreement by which anyone is restrained from exercising a lawful profession, trade or business of any kind is to that extent void. Saving of agreement not to carry on business of which goodwill is sold, exception one who sells goodwill of a business may agree with buyer to refrain from carrying on a similar business within specified local limits, so long as buyer or any person deriving title to goodwill from him carries on a like business therein, provided that such limits appear to quote reasonable regarding being had to nature of business. Article 28, agreements in restraint of a legal proceeding void. Agreement in restraint of a legal proceeding void. Every agreement by which any party thereto is restricted is restricted absolutely from enforcing his rights under or in respect of any contract by usual legal proceedings in ordinary tribunals, or which limits time within which he may thus enforce his rights, or which extinguishes rights of any party thereto, or discharges any party thereto from any liability under or in respect of any contract on expiry of a specified period, so as to restrict any party from enforcing his rights, is void to extent. Let me repeat this. Agreements in restraint of legal proceedings void. Every agreement by which any party thereto is restricted absolutely from enforcing his rights under or in respect of any contract by usual legal proceedings in ordinary tribunals, or which limits time within which he may thus enforce his rights, or which extinguishes rights of any party thereto, or discharges any party thereto from any liability under or in respect of any contract on expiry of a specified period, so as to restrict any party from enforcing his rights, is void to that extent. Saving of contract or to refer to arbitration dispute that may arise. Exception 1. This section shall not render illegal a contract by which two or more persons agree that dispute which may arise between them in respect of any subject or class of a subject shall be referred to arbitration, and that only amount awarded in such arbitration shall be recoverable in respect of dispute so referred. Now, suits barred by such contracts. When such a contract has been made, a suit may be brought for its specific performance, and if a suit other than for such specific performance or for recovery of amount so awarded is brought by one party to such contract against any other such party in respect of any subject, and they have so agreed to refer, existence of such contract shall be a bar to suit. Saving of contract to refer questions that have already arisen. Saving of contract to refer questions that have already arisen, except nor shall this section render illegal any contract in writing by which two or more persons agree to refer to arbitration any question between them which has already arisen, or affect any provision of any law in force for time being as to reference to arbitration. So this is very important one, means when you cannot force someone to agree on a contract that you shall not go to court, in fact dismisses that, and you cannot say this is time limit that you have to go. This means you cannot impact upon rights of persons on contract. Yes, there is a saving, there is a condition. If you want to go to arbitration, that contract is valid in that case if you go to arbitration or dispute. Otherwise, you cannot force someone to accept something which law doesn't accept. You cannot say sign this condition. Even if that condition is signed, that is not applicable. Law shall not accept that. This is what it means, and this is very important one. Means you cannot get everything signed according to your choice. That's not accepted. That's the importance of this law of contract. Means you have to sign contract according to this law. This is contract law. That's why I'm trying to explain to people what is contract. They should understand meaning of contract. And if they do not understand meaning of contract, they cannot do their business. Because every business is done according to contract conditions, and we always say this is contract between you and me. But that contract should be according to this act. This is called Indian Contract Act. I am explaining to you. This was first time enacted in 1857 and is still in force. And there are so many conditions, so many sections in this, and these sections are applicable only when you read them. and this is important for everybody, and but I'm trying to tell, because I am dealing with civil engineering, I am dealing with those contracts in civil engineering, and everyone deals with some contracts. This concern, it's just like this part of us. You cannot force someone to sign something which is illegal. If it's signed is illegal, it doesn't mean anything. Yes, there is a dispute, you don't want to court, you do not want to go to court for something because you want to go to arbitration, because there is an alternative mechanism for dispute resolutions. Generally, business cases or cases on contest are often referred to arbitration, which is a part of law. Arbitration is also statute, it's according to Parliament Act, Arbitration Act 1996, and before there was someone else, so you go to arbitration to save time. That's what saying. So it's very important to understand all this. And if you can understand this, you can get your life easy if you are in business or in profession. So Article 13 is agreements by way of wager void. Now what says? Agreement is Article 13. Agreements by way of wager void. Agreements by way of wager are void, and no suit shall be brought for recoveries, anything else to be won on any wager or entrusted to any person to abide result of any game or other uncertain event in which any wager is made. It says agreement by way of wager. Agreements by way of wager void. Agreements by way of wager are void, and no suit shall be brought for any recovery of anything else to be won on any wager or entrusted to any person to abide result of any game or other uncertain event on which any wager is made. Now say, if you go to now exception is there in favor of certain prizes for horse racing. This section shall not be deemed to render unlawful a subscription or contribution or agreement to subscribe or contribute made or entered into for or toward any plate, price or sum of money or of value or amount of 500 rupees. I'll leave it as all. Now it says section Indian Penal Code. No, it's not that. Come on. Chapter 3 of contingent contracts. Now chapter 3 is of contingent contracts. Contingent acts defined. Now I am going to further this one. See, my purpose was only this. If you people understand contract, it's very important in your general life also. Every day we enter contracts. We don't know that. For example, you buy railway ticket, you buy flight ticket, you buy a bus ticket. Do you know what is that? What is meaning of that ticket? Yes, it mentions prices, it mentions this is start destination, this end destination. But we should not forget that it's a contract. It's not signed standard form, but until your journey is not finished, it is contract. Contract according to this law. You use services of some provider, from some provider, or you buy some item and get receipt of that, that's also a contract. Service you get, that's also a contract. Every day you enter into many contracts which you are not aware of. But people are not aware of this law also. That's also means only those people who work in high profile, so they deal with written contracts. Contract should be written, but it's not mandatory that should be written. Sometimes verbal contracts are, you hire some worker for 1 week or for 2 days, 3 days, I shall pay you this much, work for me this. That is also a contract. So there are millions of contracts transpired every day, either in writing or in verbal speech. That's why I'm trying to let you understand what all about, because people do not know. General people don't know. That's why when I want to study further, I want to teach you further on many issues, basic knowledge of what we are doing, what we should do, just like it is, when we start learning English, we use CAT, CAT, RAT, RAT, we teach kids like that. That the same thing it is. If you do something in life, every day you deal with this. So that is contract. Two parties agree for something, that is contract. That should be legal, that should not be illegal. You cannot contract with someone, say, I am giving you so many rupees, go and kill this man. That cannot be a contract. That's against law. or that I'll sell you this red fort you sign, that's against law. What I'm saying, contract should be legal, it should be under law and applicable law. It should not be against law, it should not be against nation, it should not be against something which is immoral, which is unnatural. All those which are, you say, removed from your life and remaining is contract. You go and buy something, it's a contract. You can say, I'll do this for you and you get me this much money, that's a contract. But it should be legal. That's the sole purpose of this talk I'm making to you. And this is very important because somebody has asked me something, I want to learn this. But before you will learn some management on contract, you must know what is contract. And in fact is if you read yourself this document that is called Indian Contract Act or whatever country's act, this is a copy of British Act, it's nothing new because in 1857 there was none of our parliament, it was Parliament British. So they defined this and this is still applicable, of course with certain amendments, usual. So we should know about this. Was contingent contract in Article 31 defined, this is defined as a contingent contract. Contingent contract is a contract to do or not to do something. To do or not to do something if some event, collateral or such contract does or does not happen. Now what says Article 32, enforcement of contracts contingent on an event happening. So enforcement of contracts contingent on an event happening. Now it says Article 32, enforcement of contracts contingent on an event happening. Contingent contract to do or not to do anything if an uncertain future event happens cannot be enforced by law unless and until that event has happened. It means a possibility is there. It says enforcement of contract contingent. Contracts contingent which are not done yet. Enforcement of contract contingent on an event happening, and if some event happens, if something happens, this means that enforcement of contract contingent on an event happening. Contingent contracts to do or not to do anything if an uncertain future event happens cannot be enforced by law unless and until that event has happened. If event becomes impossible, such contract becomes void. You got this very special contingent is certain condition. For example, there can be examples. If I get this benefit in future, this shall be your right on that, like that you can sign. Okay, you expect something in future to come to you. For example, your money has to come from your hereditary property. If I get this money from my father or in future from someone else, if I get this money, this shall be your part. Subject, this is called contingent contract, means which is not with you yet. It's not happened. It may happen or may not happen. It depends upon that. So Article 33, enforcement of contracts contingent on an event not happening. Enforcement of contracts contingent on an event not happening. Contingent contracts to do or not to do anything if an uncertain future event doesn't happen can be enforced when that event happening or that event becomes impossible and not before. So its implication is, its enforcement is when that happens only, then that condition applies, that contract. Otherwise, that contract does not apply. Article 34, when event on which contract is contingent to be deemed impossible if it is future conduct of a living person. So it says when event on which contract is contingent or means is not real, probable, means in future may be contingent in this, when event on which contract is contingent to be deemed impossible if it is future contract of a living person, if future event on which a contract is contingent is way in which a person will act at an unspecified time, the event shall okay, now shall be considered to become impossible when such person does anything which renders it impossible that he should so act within any definite time or otherwise that under future contingencies. Now It is an example means just A A agrees to pay B. A agrees to pay B a sum of money if B marries C. So example is given. A agrees to pay B a sum of money if B marries C. C marries D. If B marries C, C marries D. Marriage of B to C must now be considered impossible, although it is possible that D may die and that C may afterwards marry B. This is an illustration. 35. Article 35. When contracts become void which are contingent on happening of specified event within fixed time. When contracts become void which are contingent on happening of specified event. When contracts become void which are contingent on happening of specified event within fixed time, contingent contracts to do or not to do anything if specified uncertain event happens within a fixed time becomes void if at expiration of time fixed such event has not happened, or if before time fixed such event becomes impossible. When contracts may be enforced which are contingent on a specified event not happening within fixed time, contingent contracts to do or not to do anything if a specified uncertain event does not happen within a fixed time may be enforced by law when time fixed has expired and such event has not happened, or before time fixed has expired it is become certain that such event will not happen. Now I will not give illustrations here. I will give next article because agreement contingent on impossible event void. Article 36. Agreement contingent on impossible events void. Contingent agreement to do so or not to do anything if an impossible event happens are void, whether impossibility of event is known or not to parties to agreement at time when it is made. So impossible, any agreement that is contingent on impossible events are void. Now I go to performance of contracts, chapter 4, that is performance of contracts. Contracts which must be performed. Article 37. Obligation of parties to contracts. Obligation of parties to contracts. Parties to a contract must either perform or offer to perform their respective promises unless such performance is dispensed with or excused under provisions of this Act or of any other law. Obligation of parties to contracts. Parties to a contract must either perform or offer to perform their respective promises unless such performance is dispensed with or excused under provision of this Act or of any other law. Promises bind representatives of promisors in case of death of such promisors before performances unless a contrary intention appears from contract. Now we'll say 38. Effect of refusal to accept offer of performance. Effect of refusal to accept offer of performance. Article 38. Effect of refusal to accept offer of performance. Where a promisor has made an offer. Where a promisor has made an offer of performance to promisee and offer has not been accepted, promisor is not responsible for non-performance, nor does he thereby lose his rights under contract. Every such offer must fulfill following conditions. It must be unconditional This offer to perform must be unconditional. It must be made at proper time and place and under such circumstances that person to whom it is made may have a reasonable opportunity of ascertaining that person by whom it is made is able and willing there and then to do whole of what he is bound by his promise to do. I repeat, it must be it must be made at a proper time and place and under such circumstances that person to whom it is made may have a reasonable opportunity of ascertaining that person by whom it is made is able and willing there and then to do whole of what he is bound by his promise to do. If offer is an offer, if offer is an offer to deliver anything to promisee, promisee must have a reasonable opportunity of seeing that thing offered is thing which promiser is bound by his promise to deliver. An offer to one of several joint promises has same legal consequences as an offer to all of them. Now, Article 39, effect of refusal of party to perform promise wholly. Effect of refusal. Effect of refusal of party to perform promise wholly when a party to a contract has refused to perform or disabled himself from performing his promise in its entirety. Promise may put an end to contract unless he has signified by words or conduct his acquiescence in its continuance. I repeat, effect of refusal of party to perform promise wholly when a party to a contract has refused to perform or disabled himself from performing his promise in its entirety. Promisee may put an end to contract unless he has signified by words or conduct his acquiescence of its continuance. Now we go to by whom contract must be performed. Article 40, person by whom promise is to be performed. Now, person by whom promise is to be performed. If it appears from nature of case that it was intention of parties to any contract that any promise contained in it should be performed by promiser himself, such promise must be performed by promiser. In other cases, promiser or his representatives may employ a competent person to perform it. Repeat. Person by whom promise is to be performed. If it appears from nature of case that it was intention of parties to any contract that any promise contained in it should be performed by promiser himself, such promise must be performed by promiser. Or in other cases, promiser or his representatives may employ a competent person to perform it. Article 41, effect of accepting performance from third person. Effect of accepting performance from third person. When a promisee accepts performance of promisee from a third person, says when a promisee accepts performance of promise from a third person, he cannot afterwards enforce it against promiser. That's simple. Means representative or a special person can be accepted in place of promiser in person. Article 42. Devolution of joint liability. Devolution of joint liabilities. Devolution of joint liabilities when two or more persons have made a joint promise. Then, unless a contrary intention appears by contract, all such persons during their joint lives and after death of any of them is representative jointly with survivor or survivors and after death of last survivor, representative of all jointly must fulfill promise. This is Article 42. That is devolution of joint liabilities when two or more persons have made a joint compromise. Then, unless a contrary intention appears by contract, all such persons during their joint lives and after that of any of them is representatives jointly with survivor or survivors and after death of last survivor, representatives of all jointly must fulfill promises. Article 43. Any one of joint promisers may be compelled to perform. Any one of joint promisers may be compelled to perform when two or more persons make a joint promise. Promisee may, in absence of express agreement to contrary, compel any one or more of such joint promisers to perform whole of promise. Each promiser may compel contribution. Each promiser may compel contribution. Each of two or more joint promisers may compel every other joint promiser to contribute equally with himself to performance of promise, unless a contrary intention appears from contract. Now, Article 36. Sharing of loss by default in contribution. If anyone of two or more joint promisers make default in such contribution, remaining joint promisers must bear loss arising from such default in equal share. That is what it is. Now, I'll go to further. In this explanation is given, nothing in this section shall prevent a surety from recovering from his principal payments made by surety on behalf of principal, or entitled principal to recover anything from surety on account of payment made by principal. Alright, now it's example. Article 44. Effect of release of one joint promiser. Effect of release of one joint promiser where two or more persons have made a joint promise. A release of one of such joint promiser by promisee does not discharge other joint promiser or joint promisers. Neither does it free joint promisers so released from responsibility to other joint promiser or joint promisee. 45. Devolution of joint rights. Devolution of joint rights when a person has made a promise. When a person has made a promise to two or more persons jointly, then unless a contrary intention appears from contract, right to claim performance rests as between him and them, with them during their joint lives and after death of any of them, with representatives of such deceased person, jointly with survivor or survivors, and after death of last survivor, with representatives of all jointly, I repeat, devolution of joint rights. Devolution of joint rights when a person has made a promise to two or more persons jointly, then unless a contrary intention appears from contract, right to claim performance rests as between him and them, with them during their joint lives, and after death of any of them, with representatives of such deceased person jointly with survivor or survivors, and after death of last survivor with representatives of all jointly. So we'll go to now time and place for performance, that is 46. Time and place, time and performance of promise when no application is to be made and no time is specified, article 46. Time for performance of promise when no application is to be made and no time is specified, whereby contract a promiser or to perform his promise without application by promisee, and no time for performance in specified engagement must be performed within a reasonable time. I repeat, this is time for performance or promise, time for performance of promise when no application is to be made and no time is specified, whereby the contract a promiser is to perform his promise without application by promisee, and no time for performance is specified. Engagement must be performed within a reasonable time. And what is reasonable time is in each particular case a question of fact. Article 40, Section 47, time and place of performance of promise where time is specified and no applications to be made. Article 47, time and place for performance of promise where time is specified and no application to be made, when promise is to be performed on a certain day and promiser has undertaken to perform it without application by promisee. Promiser may perform it at any time during usual hours of business on such day and at place at which promise ought to be performed. After Article 48, Section 48, application for performance on certain day to be at proper time and place. Now, application for performance on certain day to be at proper time and place when a promise is to be performed on a certain day and promiser has not undertaken to perform it without application by promisee, it is duty of promisee to apply for performance at a proper place and within usual hours of business. Then 49, Section 49, place for performance of promise where no application to be made and no place fixed for performance. Place for performance of promise where no application to be made and no place fixed for performance, when a promise is to be performed without application by promisee and no place is fixed for performance of it, it is duty of promiser to apply to promisee to appoint a reasonable place for performance of promise and to perform it at such place. 50. Section 50. Performance in manner or at time prescribed or sanctioned by promises. Performance in a manner or at time prescribed or sanctioned by promisee. Performance of any promise may be made in any manner or at any time which promisee prescribes or sanctions. 30. This is 50 now. We go to start. 51. Performance of reciprocal promises. Performance of reciprocal promises. 51. Promiser not bound to perform. Promiser not bound to perform unless reciprocal promisee ready and willing to perform. Promiser not bound to perform unless reciprocal promisee ready and willing to perform. When a contract consists of reciprocal promises to be simultaneously performed, no promiser need perform his promise unless promisee is ready and willing to perform his reciprocal promise. 52. Order of performance of reciprocal promise. Order of performance. Order of performance of reciprocal promises, where order in which reciprocal promises are to be performed is expressly fixed by contract. They shall be performed in that order, and where order is not expressly fixed by contract, they shall be performed in that order which nature of transaction requires. Then 53. Liability of party preventing event on which contract is to take effect. Section 53. Liability of party preventing event on which contract is to take effect. When a contract contains reciprocal promises and one party to contract prevents other from performing his promise, contract becomes voidable at that option of party so prevented, and he is entitled to compensation. I repeat, liability of party preventing event on which contract is to take effect. When a contract contains reciprocal promises and one party to contract prevents other from performing his promise, contract becomes voidable at option of party so prevented, and he is entitled to compensation. Then it is the other party for any loss which he may sustain in consequence of non-performance of contract. So 54. Effect of default as to that promise. Effect of default as to that promise which should be first performed in contract consisting of reciprocal promises. Hence, effect of default as to that promise which should be first performed in contract consisting of reciprocal promises. When a contract consists of reciprocal promises, I think you understand reciprocal, such that one of them cannot be performed or that its performance cannot be claimed till other has been performed, and promiser of promise last mentioned fails to perform it, such promiser cannot claim performance of reciprocal promise and must make compensation to other party to contract for whatever loss which such other party may sustain by non-performance of contract. Let's read it again. Effect of default as to that promise which should be first performed. Effect of default as to that promise which should be first performed in contract consisting of reciprocal promises. Effect of default as to that promise which should be first performed in contract consisting of reciprocal promises when a contract consists of reciprocal promises such that one of them cannot be performed or that its performance cannot be claimed until till other has been performed, and promiser of promise last mentioned fails to perform it, such promiser cannot claim performance of reciprocal promise and must make compensation to other party to contract for any loss which such other party may sustain by non-performance of contract. Article 55, Section 55, effect of failure to perform at fixed time in contract in which time is essential. Well, these are very small sections but very important for contracts because the contents of sections are not very expensive, but when you apply on contracts, it result in havoc. 55. Effect of failure to perform at fixed time. In contract in which time is essential. In contract in which time is essential, when a party to a contract promises to do a certain thing at or before a specified time, or certain things at or before specified times, and fails to do any such thing at or before a specified time, contract or so much of it as has not been performed becomes voidable at option of promisee. If intention of parties was that time should be of essence of contract, effect of such failure when time is not essential, effect of such failures when time is not essential, if it was not intention of parties that time should be of essence of contract, contract does not become voidable by failure to do such thing at or before a specified time, but the promisee is entitled to compensation from promisor for any loss occasioned to him by such failure. Effect of acceptance of performance. Effect of acceptance of performance at time other than that agreed upon. If in case of contract voidable on account of promisor's failure to perform his promise at time agreed, promisee accepts performance of such promise at any time other than that agreed, promisee cannot claim compensation for any loss occasioned by non-performance of promise at that time agreed, unless at time of such acceptance he gives notice to promisor of his intention to do so. Let me repeat this 55 whole. This is actually very dominating here. Time is involved, so must be clearly understood. Let me see first now how there. We will go back to that material and see. Mr. Sir, welcome. Mr. Suraj, good morning. Mr. Sundar Singh, good morning. Mr. Gulam, join. Good morning, Mr. Gulam, who's there? I say good morning. Good morning, all right. Then this is like to send that. That was there. गुलाम चलाने join. Alright. Alright, I'll continue. Now, I was talking on 55. Says effect of failure. I am repeating 55 because it's a little complicated, time is involved. Effect of failure to perform at fixed time. In contract in which time is essential. When time is essential, talking when a party to a contract promises to do a certain thing at or before a specified time, or certain things at or before specified times, and fails to do any such thing at or before a specified time, contract or so much of it has not been performed, becomes voidable at option of promisee. Voidable at option of promisee. If intention of parties was that time should be of essence of contract. Effect of such failures when time is not essential. And when time is not essential, what happens? Effect of such failures when time is not essential, if it was not intention of parties that time should be of essence of contract. Contract does not become voidable by failure to do such thing at or before a specified time. But promisee is entitled to compensation from promiser for any loss occurred occasioned to him by such failure. Now, effect of acceptance of performance at time other than that agreed upon, if it's some other time done, you mean to say, if in case of contract voidable on account of promiser's failure to perform his promise at time agreed, promisee accepts performance of such promise at any time other than that agreed, promisee cannot claim compensation for any loss occasioned by non-performance of promise at time agreed, unless at time of such acceptance he gives notice to promiser of his intention to do so. Now 56. Agreement to do impossible act. Agreement to do impossible act. An agreement to do an act impossible in itself is void. Simple. Agreement to do impossible act. An agreement to do an act impossible in its is void. Contract to do an act afterwards becoming impossible or unlawful. A contract to do an act which after contract is made becomes impossible, or by reason of some event which promiser could not prevent, unlawful, becomes void when act becomes impossible or unlawful. Compensation for loss through non-performance of act known to be impossible or unlawful, where one person has promised to do something which he knew or with reasonable diligence might have known, and which promisee did not know to be impossible or unlawful, such promiser must make compensation. Such promiser must make compensation to such promisee for any loss which such promises sustains through non-performance of promise. Again, this is a little complicated. Let me read again. Agreement to do impossible. Agreement to do impossible act. An agreement to do an act impossible in itself is void. I'll show you actually which I'm trying to, let me just make this, because I have gone through about 36 of 98 pages and I forgot to actually tell you where is this, what actually it is. Let me see where it is in my mobile. Is it there or not? Let me clear this. Mm. Yes, I'll see. Let me see. To be clear of that, actually, what I'm talking of is for the Indian Contract Act here. Indian Contract Act. Let me actually show you where I'm talking about that. It's a document I'm showing to you. Then I will show you this one. Can you see this? I don't know. You can see this or not. It's very small. Let me see it. Let me see this actually. This is what I'm talking of actually. It will be clear that it's not very finely this text document. It's this document I'm talking of. Indian Contract Act. Indian Contract Act 1872. I'm talking of this one, maybe clear, maybe I'm not clear. I'm just confirming that I'm talking Indian Contract Act. You can refer to, if you have this, you can download from internet. If you don't have, it's not a big deal. You can download from there. For example, I was now on Article 50, Chapter 1, for example, this Chapter 1. For example, I am now here on Article 55, and I should say where it is. Yes, yeah. This is Article 55 on this. I'm talking of this Article 55, it's here. Let me continue. I'll do it later on because Article 55, let's see. So 55 are done. Now maybe I repeat that, doesn't make a difference if I repeat that. Article 55 once again. because it is time consuming, it's time work. Effect of failure to perform at fixed time. Article 50 section sorry I'm speaking sorry section 55. Article is actually for Constitution of India. In sections, this is sections in statutes, not articles. Section 55, effect of failure to perform at fixed time in contract in which time is essential. When a party to a contract promises to do a certain thing at or before a specified time, or certain things at or before a specified time, and fails to do any such thing at or before specified time, contract or so much of it as has not been performed becomes voidable at option of promisee. Promisee, see, first understand promiser and promisee. A person who has submitted a proposal is a promise, and a person who accepted this is a promisee. So here I am saying promisee. So there becomes voidable at option of promisee. Who accepted this is a promisee. So it's up to promisee if something is not an indefined time, whether to accept it or to give another time, allow another time. If intention of party was that time is not, intention of party was that time should be of essence on contract. Effect of such failure when time is not essential. If time is not essential, how it happens? Effect of such failure when time is not essential. If it was not intention of parties that time should be of essence of that contract does not become voidable by failure to do so, by do such thing as at or before specified time, but promisee is entitled to compensation from promiser for any loss occurred occasion to him or such failure. Effect of acceptance of performance at time other than that agreed upon if in case of a contract voidable on account of promiser's failure to perform his promise at time agreed. Promisee accepts performance of such promise at any time other than that agreed. Promisee cannot claim compensation for any loss occasioned by non-performance of promise at time agreed, unless at time of such acceptance he gives notice to promisee of his intention to do so. So now 56, agreement to do impossible act. Agreement to do impossible act. It says 56. Let's say here 56. 56. Let me block because I cannot read otherwise. Yeah, there is 56. Let me see here. Says agreement to do impossible act. An agreement to do an act impossible in itself is void. Contract to do act afterwards becoming impossible or unlawful. A contract to do an act which after contract is made becomes impossible or by reason of some event which promiser could not prevent, unlawful, becomes void when act becomes impossible or unlawful. Compensation for loss through non-performance of act known to be impossible or unlawful, where one person had promised to do something which he knew or with reasonable diligence might have known, and which promises did not know. Promisee did not know to be impossible or unlawful. Such promiser must make compensation to such promisee for any loss which such promisee sustains through non-performance of promise. Let me repeat this. Sorry. Let me repeat this. Agreement to do impossible act. An agreement to do an act impossible in itself is void. Contract to do act afterwards becomes impossible or unlawful. A contract to do an act which after contract is made becomes impossible, or by reason of some event which promiser could not prevent, unlawful, become void when act becomes impossible or unlawful. Compensation for loss through non-performance of act known to be impossible or unlawful, where one person has promised to do something which he knew or with reasonable diligence might have known, and which promise he did not know to be impossible or unlawful. Such promiser must make compensation to such promisee for any loss which such promisee sustains through non-performance of promise. Is very clear? Now, section 57, reciprocal promise to do thing legal and also other thing illegal. 57. Reciprocal promises. So we'll go through that. Reciprocal promises. Right. Reciprocal promise to do things legal, and also other things illegal. Where persons reciprocally promise, firstly to do certain things which are legal, and secondly, under specified circumstances, to do certain other things which are illegal. First set of promises is a contract, but second is a void agreement. Means whatever you agreed according to law is legal is a part of contract, and whatever is illegal cannot be a part of contract. Let me read it. Reciprocal promises to do things legal and also other things illegal, where persons reciprocally promise firstly to do certain things which are legal, and secondly, under specified circumstances, to do certain other things which are illegal. First set of promises based on legality is a contract, but second, which is illegal, is void agreement. Come on to 58. Alternative promise, one branch being illegal. Let us say what it says. 58. 58. This is 58. So I show you here 58. Alternative promise, one branch being illegal in case of an alternative promise, one branch of which is illegal and other illegal. Legal branch alone can be enforced. 50. This is valid contract. Let's say example is there for say A and B agree that A shall pay B 1000 rupees. This is a condition. A and B agree that A shall pay B 1000 rupees, for which B shall afterwards deliver to A either rice or smuggled opium. Rice or smuggled opium. This is a valid contract to deliver rice and a void agreement as to deliver opium. That's what it says. Simple. Now 59. Appreciation of payments. Application of payment where debt to be discharged is indicated. 59. Application of payment. I'll show you this one. Application of payment. Application of payment where debt to be discharged is indicated, where a debtor owing several distinct debts to one person makes a payment to him either with express intimation or under circumstances implying that payment is to be applied to discharge of some particular debt. Payment, if accepted, must be applied accordingly. Item 60, section 60. Application of payment where debt to be discharged is not indicated. Application of payment. So we'll show that. Maybe not clear because the printer like that now. Let's say application of payment where debt to be discharged is not indicated, where debtor has omitted to intimate and there are no other circumstances indicating no to which debt payment is to be applied. Creditor may apply it at his discretion to any lawful debt actually due and payable to him from debtor, whether its recovery is or is not barred by law in force for time being as to limitation of suits. And 61. Application of payment where neither party appreciates. 61. Maybe you cannot read on the clear one, not the problem, at least information is there. So application of payment where neither party appropriates, where neither party makes any appropriation, payment shall be applied in discharge of debts in order of time, whether they are or or are in bar not barred by law in force for time being as to limitation of suits. If debts are of equal standing, payment shall be applied in discharge of each proportionally. Now repeat it. Application of payment where neither party appropriates, where neither party makes any appropriation, payment shall be applied in discharge of debts in order of time, whether they are of are not barred by law in force for time being as to limitation of suits. If debts are of equal standing, payment shall be applied in discharge of each proportionately. An item section 62, effect of novation, rescission and alteration of contract. This is very important part. I am going to do that. Effect of novation, rescission and alteration of contract. Item 62, effect of novation, rescission and alteration. Novation, rescission and alteration. This is actually very important point. Novation, very important from certain point of view. Let's say so we go on novation. That's the effect of novation, rescission and alteration of contract. If parties to a contract agree to substitute a new contract for it or to resign or alter, resign means cancel, or to alter means change it, original contract need not be performed. Let's understand what is this. Novation, rescission, alteration. Novation is something, in a way you can recondition that contract, recondition that in any way. Rescission is stop that contract or cancel that contract, and alteration of contract means some alteration. So effect of novation, rescission and alteration of contract. If parties to a contract agree to substitute a new contract for it, or to resign or alter it, original contract need not be performed because we have changed it, we have replaced it. So that's the meaning of this. I'll explain this in details later on. Promisee may dispense with or remit performance of promise. Now let us say 63 promisee, 63. Promisee may dispense with 63. Let us say 63 it is. Promisee may dispense with or remit performance of promise. Every promisee may dispense with or remit wholly or in part performance of promise made to him, or may extend time for such performance, or may accept instead of it any satisfaction which he thinks fit. Consequences of rescission of voidable contracts is 64. 64 consequences of rescission of voidable contract. 64. Consequences of rescission of voidable contract. When a person at whose option a contract is voidable resigns it, other party thereto need not perform any promise therein contained in which he is promisor. Party resigning a voidable contract shall, if he have received any benefit thereunder from another. Party resigning a voidable contract shall, if he have received any benefit thereunder from another party to such contract, restore such benefits so far as may be to person from whom it was received. 65. Obligation of person who has received advantage under void agreement or contract that becomes void. 65. $65. Let me see. Obligation of person who has received advantage under void agreement or contract that becomes void when an agreement is discovered to be void, or when a contract becomes void. Any person who has received any advantage under such agreement or contract is bound to restore it or to make compensation for it to person from whom he received it. $66. 66. Mode of communicating or revoking rescissions of voidable contracts. 66. Mode of communication or revoking rescission of voidable contract. Rescission of a voidable contract means may be communicated or revoked in same manner and subject to same rules as applied to the communication or revocation of a proposal. 67. Effect of neglect of promise to afford promise reasonable facilities for performance. Effect of neglect of promise. Effect of neglect of promise to afford promiser reasonable facilities for performance. 67. Let us say effect of neglect of promises to afford promiser reasonable facilities for performance. If any promises neglects or refuses to afford promisee reasonable facilities for performance of this promise, promiser is excused by such neglect or refusal as to any non-performance caused thereby. Now, chapter 5, that's of certain relations resembling those created by contract. Chapter 5 of certain relations resembling those created by contract that we are going to do. Let us see my friend what. Who is there? I don't know. So I am going this. This is chapter. I said this is another one. It's chapter 5. Yes, chapter 5. Chapter 5. This is here. Yes, chapter 5 of certain relations resembling those created. Chapter 5. Okay. Certain relations resembling those created by contract are 68. Claim for necessaries supplied to person incapable of contracting or on his account. Claim for necessaries supplied to person incapable of contracting or on his account if a person incapable of entering into a contract or anyone whom he is legally bound to support is supplied by another person with necessaries suited to his condition in life. Person who has furnished such supplies is entitled to be reimbursed from property of such incapable person. Let me read it again. Claim for necessaries supplied to person incapable of contracting or on his account if a person incapable of entering into a contract or anyone whom he is legally bound to support is supplied by another person with necessaries suited to his condition in life. Person who has furnished such supplies is entitled to be reimbursed from property of such incapable person. Then go to then 69. Reimbursement of person paying money due to another in payment of which is interested. 69. Reimbursement of payment, reimbursement of person paying money, reimbursement of person paying money due by another in payment of which he is interested. A person who is interested in payment of money which another is bound by law to pay, and who therefore pays it, is entitled to be reimbursed by other. Now we will go to 70. Obligation of person enjoying benefit of non-gratuitous act. Gratuitous act. Obligation of person enjoying benefit of non-gratuitous act. 70. Obligation of a person enjoying benefits of non-gratuitous act, where a person lawfully does anything for another person, or delivers anything to him, not intending to do so gratuitously, and such other person enjoys benefit thereof, later is bound to make compensation to former in respect of, or to restore thing so done or delivered. Now it is 71. It is responsibility of finder of goods. I think 70 it was before. 71 or 70. 71. Responsibility of a finder of goods. Okay, 71. It's very boring subject, I know, but what can I do? It's not in my hands to make it interesting. It's in my hand to understand it. That's important. Interesting is that. Understand it. It's more important than something else to understand it. Responsibility of finder of goods. A person who finds goods belonging to another and takes them into his custody is subject to same responsibility as a bailee. Means a person who finds goods belonging to another and takes them into his custody is subject to same responsibility as a bailee. 72. Liability of person to whom money is paid or thing delivered by mistake or under coercion. 72. 72. Liability of a person. Liability of a person to whom money is paid or thing delivered by mistake or under coercion. A person to whom money has been paid or anything delivered by mistake or under coercion must repay or return it. Consequences of breach of contract. Consequences of breach of contract. This is chapter 6. Okay, let's go further. Yes, consequences of breach of contract. 73. Compensation for loss or damage caused by breach of contract. When a contract has been broken, party who suffers by such breach is entitled to receive from party who has broken contract compensation for any loss or damage caused to it thereby, which naturally arose in usual course of things from such breach, or which parties knew when they made contract to be likely to result from that breach. I repeat, when a contract has been broken, party who suffered by such break or such breach is entitled to receive from party who has broken contract compensation for any loss of damage caused to him thereby, which naturally arose in usual course of thing from such likely, or which partners knew you got it partners knew when they made contract to be likely to result from breach of it. So I read this paragraph again. Compensation for loss of damage caused by breach of contract. When a contract has been broken, party who suffers by such breach is entitled to receive from party who has broken contract compensation for any loss or damage caused to him thereby, which naturally arose in usual course of thing from such breach, or which parties knew what they made a contract to be likely to result from breach of it. Such compensation is not to be given for any remote and indirect loss or damage sustained by reason of breach. Compensation for failure to discharge obligation resembling those created by contractor. By contract, when an obligation resembling those created by contract has been incurred and now has not been can say such compensation is not to be given for any remote and indirect loss or damage sustained by reason of breach. Compensation for failure to discharge obligation resembling those created by contract when when an obligation is resembling those created by contract has been incurred and has not been discharged. Any person injured by failure to discharge it is entitled to receive same compensation but same compensation from party in default as if such person had such person had contracted to discharge it and had broken his contract. Now, explanation in estimating loss of damage arising from a breach of contract means which existed of remedying inconvenience caused by non-performance of contract which act must be taken into account. Now, it is this is now the 73. So we'll take now 74. Now it is 70. 74. 74. Seventy-four is here. About 74. It's not very clear, even then not to. Compensation for breach of contract where penalty is stipulated for when a contract has been broken if sum is named in contract as amount to be paid in case of such breach, or if contract contains any other stipulation by way of penalty Party party complaining of breach is entitled. Party complaining of breach is entitled whether or not actual damage or loss is performed to have been caused, thereby to receive from party who has broken contract reasonable compensation not exceeding amount so named, or case may be penalty stipulated for. You get it or not? I'll repeat it. It's important. Compensation for breach of contract where penalty stipulated for when a contract has been broken. If a sum is named in contract or amount to be paid in case of such breach, or if contract contained any other stipulation or by way of penalty, and compensation for breach of contract where penalty stipulated for when a contract has been broken, if a sum is named in contract as amount to be paid in case of such breach, or if contract contains any other stipulation by way of penalty. Alright, so ये कहाँ से आ गया? Again, compensation for breach of contract where penalty is stipulated for when a contract has been broken, if sum is named in contract as amount to be paid in case of such breach, or if contract contains any other stipulation by way of penalty, party complaining of breach is entitled whether or not actual damage of loss is proved to have been caused, thereby to receive from party who has broken contract reasonable compensation not exceeding amount so named, or as case may be penalty stipulated for. Then we go to item number 75. I think we have done this 74. Maybe some missing 74. 74 was that, so it is 75. 75 party rightfully rescinding contract. 75 75 partly rightfully rescinding contract. Partly rightfully rescinding contract. So 75 party rightfully rescinding contract, rescinding or cancelling contract, entitled to compensation. A person who rightfully resigns a contract is entitled to compensation for any damage which he has sustained through non-fulfillment of contract. Now next chapter, chapter 7, and that is indemnity and guarantee. Indemnity and guarantee. Says alright, 124. 124 Contract of indemnity. A contract by which one party promises to save other from loss caused to him by conduct of promisor himself or by promisor himself. Let me read again. Contract of indemnity. Contract by which one party promises to save other from loss caused to him by the conduct of promisor himself or by conduct of any other person is called a contract of indemnity. I'll read this. 124 it is giving. Alright, let me read this. Okay. Now still I am around halfway only. It's only halfway and it's very important act. Maybe it's too boring for people, but it's very important from various point of views. Maybe boring, of course, boring. It is important to understand this contract. So, contract of indemnity, I told you, a contract by which one party promises to save other from losses caused to him by conduct of promisor himself or by conduct of any other person is called a contract of indemnity. Okay, now let's go further a little. 125 says right of 125 right of indemnity holder when used. 125. Rights of indemnity holder. When issued promisee in a contract of indemnity acting within the scope of his authority is entitled to recover from promisor. Right of indemnity holder. When promisee in a contract of indemnity acting within the scope of his authority is entitled to recover from promisor all damages which he may be compelled to pay in any suit in respect of any matter to which promisee to indemnify applies. All costs which he may be compelled to pay in any such suit, if in bringing or defending it he has not contravened orders of promisor and scared yes, he did not contravene order of promisor and scared as it winds. Acted as it would not have been prudent for him to act in absence of any contractor of indemnity or promisor authorized him to bring defend suit. I'll read all this again. I'm sure you're I will read this all 25. 125 is a little bit unclear to people. I will take time. I will not go fast on this. If it's not clear, there's no meaning. What is there? No problem. Let already go. So, what to say? (125) again. Rights of indemnity holder. When should promisee in a contract. Promisee, is promisee? Person who accepted that contract. Promisee in a contract of indemnity acting within the scope of his authority is entitled to recover from promisor all damages which may be compelled to pay in any suit in respect of any matter to which the promise is to indemnify indemnity applies. All costs which he may be compelled to pay in any such suit if in bringing or defending it he did not contravene orders of promisor and acted as it would have been prudent for him to act in the absence of any contract or indemnity. Repeat, once again repeat because it's clear. right of indemnity holder when sued, promise promisee in a contract of indemnity acting within scope of his authority is entitled to recover from promisor all damages which he may be compelled to pay in any suit in respect of any matter to which promisor pays. All damages which he may be compelled to pay in any suit in respect of any matter to which promise is indemnity applies. Promise to indemnity applies all costs which he may be compelled to pay in any such suit if in bringing or defending it he did not contravene orders of promisor and acted as it would have been prudent for him to act in absence of any contract of indemnity, or if promisor authorized him to defend the suit. All costs which he may be all sums which he may have paid under the terms of any compromise of any such suit if company was not like to say, all sums which he may have paid under terms of any compromise of any such suit, if compromise was not contrary to orders of promisor and was one which it would have been prudent for promisee to make it in absence of any contract. Okay, 126. Contract of guarantee, surety, principal, debtor, creditor. 126. 126. Contract of guarantee, surety, principal, that will show you. I think you download this act for your oil better, because it's important to understand it to implement, in your life also it can be used. So contract of guarantee, surety, principal, debtor and creditor. Now, contract of guarantee is a contract to perform, promise or discharge liability of a third person in case of his default. Person who gives Person who gives guarantee is called surety. Person who gives guarantee is called surety. You must have seen in court, Jamanat, bail, वगैरह. Surety. Person in respect of whose default guarantee is given. Person in whose default guarantee is given is called principal debtor. Principal debtor. Okay. Person who gives guarantee is called surety. Person in respect of whose default guarantee is given is called principal debtor. Principal debtor. And person to whom guarantee is given is called creditor. Person to whom guarantee is given is called creditor. A guarantee may be either oral or written. Then 127, consideration for guarantee. Consideration for guarantee. Now, this is consideration for guarantee. Consideration for guarantee. For guarantee. Now anything done, or any promise made, anything done or any promise made for benefit of principal debtor may be a sufficient consideration to surety for giving guarantee. Go to next one. 128, surety's liability. Surety's liability 128. So these are very important points which we do something where we can be trapped. We know what is that. It's now is 128. Surety's liability. What surety's liability is? Surety's liability of surety is coextensive with that of principal debtor unless it is otherwise provided by contract. Surety's liability of surety is coextensive with that of principal debtor unless it is otherwise provided by contract. Now, continuing guarantee, 29, continuing guarantee. continuing guarantee. Continuing guarantee which extends to a series of transactions is called a continuing guarantee. A guarantee which extends to a series of transactions is called a continuing guarantee. Then it is 130, which is revocation of continuing guarantee. 130, revocation of continuing guarantee. Sorry, I think in one place. Revocation of continuing guarantee. Revocation of continuing guarantee. A continuing guarantee may at any time be revoked by surety as to future transactions by notice to creditor. Means continuing guarantee. It is now 130, revocation of continuing guarantee. A continuing guarantee may at any time be revoked by surety as to further transactions by notice to creditor. 131, revocation of continuing guarantee by surety's death. Revocation of continuing guarantee by surety's death. So, the revocation of continuous guarantee by surety's death. Death of surety operates in absence of any contract to contrary as a revocation of continuing guarantee so far as regards future transactions. Once again, revocation of continuing guarantee by surety's death. Death of surety operates in absence of any contract to contrary as revocation of a continuing guarantee so as far as regards future consideration transactions. 132 is liable of two persons primarily liable not affected by arrangement between them. I think it's clear. Maybe it's not very clear what to do. 132 liability of two persons, primarily liable, not affected by arrangement between them. Liability of two persons, primarily liable, not affected by arrangement between them, that one shall be surety on other's default. When two persons contract with a third person, to undertake a certain liability and also contract with each other that one of them shall be liable only on the fault of other. Third person not being a party to such contract, liability of each of such two persons to third person under first contract is not affected by existence of second contract. Very complicated analysis. Third person not being a party to such contract, liability of each of such two persons to third person under first contract is not affected by existence of second contract or second contract. It's interesting, in fact. This third person is coming in for what? Liability of two persons. Liability of two persons, primarily liable, not affected by arrangement between them, that one shall be surety and others default, surety on others default, where two persons contract with a third person to undertake a certain liability and also contract with each other that one of them shall be liable only on the fault of other. Third person not being a party to such contract. Liability of each of such two persons to third person under first contract is not far. You got it? Let me read it again. It's little, short is liabilities. Liability of two persons primarily liable, not affected by arrangement between them, one shall be surety on others default, where two persons contract with a third person to undertake a certain liability and also contract with each other that one of them shall be liability only on the fault of other. Third person not being a party to such contract, liability of each of such two persons and also contract with each other that one of them shall be liable only on the faults of other. Third person not being a party to such contract, liability of each of such two persons to third person under first contract is not affected by existence of second contract. Although such third party and liability of each of such two persons to third person under first contract is not affected by existence of second contract although such third person may have been aware of its existence. Now 133, discharge of surety by variance in terms of contract. 133. Discharge of surety by variance. No. This is discharge of surety by variance, 133. Discharge of surety by variance in terms of contract. Discharge of surety by variance in terms of contract. Any variance made without surety's consent. Any variance made without surety's consent in terms of contract between principal 1, debtor and creditor, discharges survey surety as to transactions subsequent to variance. Discharge of surety by variance in terms of contract. Any variance made without surety's consent. Any variation or variance made without surety's consent in terms of contract between principal, debtor and creditor, discharges surety as to transactions subsequent to variance. Then come to section 134, which is discharge of surety or release of discharge surety. 134 is legal surety. So let us see title of this. Discharge of surety. Discharge of surety by release or discharge of principal debtor. Discharge of surety by release or discharge of principal debtor. Surety is discharged by any contract. Surety is discharged by any contract between creditor and principal debtor, by which principal debtor is released, or by any act or omission of creditor, legal consequences of which is discharge of principal debtor. Then 135. 135. Discharge of surety when creditor. Alright. 135. Let us see 135. No walking, what to do? Discharge of surety when creditor compounds with, gives time to, or agree not to show principal debtor. A contract between creditor and principal debtor by which creditor makes a composition with or promises to give them time to or not to show principal debtor discharge or surety unless system of. Now again, discharge of surety when creditor compounds with, gives time to or agrees not to show principal debtor. A contract between creditor and principal debtor by which creditor makes a composition with or promising to give time to or not to show this principal debtor discharge this principal debtor discharge pay discharge his promises to now. I'll go to 136. 136 is also, well, I may not finish today. This is why I like to finish 136. This surety not discharged an agreement. Let me show you what is this. Okay, let's see 136. Surety not discharged when agreement made with third person to give time to principal debtor, where a contract to give time to principal debtor is made by creditor with a third person and not with principal debtor. When so 136. Surety not discharged when agreement made with third person to give time to principal debtor. Where a contract to give time to principal debtor is made by creditor with a third person and not with principal debtor, surety is not discharged. Again I read, surety not discharged when agreement made with third person. Third person to give time to principal debtor where a contract to give time to principal debtor is made by creditor with a third person and with principal debtors, surety is not acceptable. Alright, now come to 137. Creditor's forbearance to sue does not discharge surety. Hmm, 37. One 37. It's 58 or 98 pages. I'm not sure what's the complete. Let's run as much as possible. Creditor's forbearance to show does not discharge surely. Mere forbearance on part of creditor to show principal debtor or enforce any other remedy against him does not abstain to any part. One 37, let's see now. 137, 138, maybe I'm confused. 137, yes. Creditor's forbearance to sue does not discharge surety. Mere forbearance on part of creditor to sue principal debtor or to enforce any other remedy against him does not, in absence of any provision in guarantee to contrary discharge surety. Creditor's forbearance to sue does not discharge surety. Mere forbearance on part of creditor to sue principal debtor or to enforce any other remedy against him does not in absence of any provision in guarantees to that of right? Is that of creditor's forbearance to sue does not discharge surety. Mere forbearance on part of the creditor to sue principal debtor or to enforce any other remedy against him does not, in absence of any provisions lay Alright, it's clear. Little more complications with 138. 130 is release of one co-surety does not discharge others. Release of one co-surety. 138. Release of one co-surety does not discharge others. I am going into this one because this is contract issue and it's very confusing sometimes. We have to understand clearly. Got this impacts on cost and contract acting 138. So release of one should doesn't discharge others. This is vital, and to goes better than all other things, because this is a contract and must be done accordingly. This is long-term effect. Who's there? What's happened? Something wrong somewhere. So, all right. No, it is 138, right? 138. I take 138. Release of one co-surety does not discharge others. Where there are co-sureties, a release by creditor of one of them, a release by creditor of one of them does not discharge others. Neither does it free surety so release from his responsibility to other surety. 139 139 139 is discharge of surety by creditors act. Discharge of surety by creditors act or omission impairing surety's eventual remedy. 139. Discharge of surety by creditor 139. Oh, what has come here? What's this? See more like video event log. What is? Why is coming? What's it? This will has not received video signals from video source for some time, but check that time connectivity. What is that? I don't know what it's talking of. Sometime unnecessary messages comes. Unnecessary message comes. Well, it's just disturbs, So, discharge of surety by creditors act or omission. Discharge of surety by creditors act or omission impairing surety's eventual remedy if creditor does any act which is inconsistent with rights of surety or omits to do any act which his duty to surety requires him to do, and eventual remedy of surety himself against principal debtor is thereby impaired, surety is discharged. Let me read it again. Discharge of surety by creditors act or omission impairing surety's eventual remedy, if creditor does any act which is inconsistent with rights of surety or omits to do any act which his duty is to surety requires him to do, and eventual remedy of surety himself against principal debtor is thereby impaired, surety is discharged. 140. Rights of surety on payment or performance. 140. Right of surety. 140 is the right of surety. It's little not clear in this, doesn't matter. 140 you can see, and then you can see it's little clear now, I see. Alright, then we go to so 140. Rights of surety on payment. Rights of surety on payment or performance where a guaranteed debt has become due or default of principal debtor to perform a guaranteed duty has taken place. Surety upon payment or performance of all that he has liable for is invested with all rights which creditor had against principal debtor. Let me read again. 140. Rights of surety. Rights of surety on payment or performance where a guaranteed debt has become due or default of principal debtor to perform a guaranteed duty. A guaranteed duty has taken place. Surety upon payment for performance of all that he is liable for is invested with all rights which creditor had against principal debtor. 141 is now surety's rights to benefit of creditors' securities. Surety's rights. 141. Surety's rights. Surety's right. 141. Surety's right to benefit of credited securities is surety is entitled to benefit of every security which creditor has against principal debtor at time when contract of suretyship is entered into. Suretyship is entered into. Whether surety knows or I'm missing, I think something there I'm missing. Just surety's right to benefit of creditor's surety. A surety is entitled to benefit of every security which creditor has against principal debtor at time when contract of suretyship is entered into, whether surety knows of existence of such security or not. Right. Say again, I read it. Surety's right to benefit of creditor securities. A surety is entitled to benefit of every security which creditor has against principal debtor at time when contract of suretyship is entered into, whether surety knows of existence of such security or not, and if creditor loses or without consent of surety parts with such security, surety is discharged to extent of value of security. 141, 142. 142. Guarantee obtained by misrepresentation invalid. Guarantee represented by misrepresentation. One 42. This is guarantee obtained by misrepresentation invalid. Any guarantee which has been obtained by means of misrepresentation made by creditor or with his knowledge and assent concerning material part of transaction is invalid. 143. Guarantee obtained by concealment invalid. Guarantee obtained by concealment छुपाना. Guarantee obtained by concealment invalid. Any guarantee which creditor has obtained by means of keeping silence as to material circumstances is invalid. 144. 144 is guarantee on contract. Guarantee on contract, that is 144. Guarantee on contract that creditors shall not act guarantee on contract that creditors shall not act. Guarantee on contract that creditors shall not act on it until co-surety joins. Guarantee on contract that creditors shall not act on it until co-surety joins, where a person gives a guarantee upon a contract that creditors shall not act upon it until another person has joined in it as co-surety. Guarantee is not valid if that other person does not join. So again I read, this is an important point. 144. This is guarantee on contract that creditors shall not act on it until co-surety joins, when a person gives a guarantee upon a contract that creditors shall not act. 144 says, says 144, guarantee on contract that creditors shall not act on it until co-surety joins, where a person gives a guarantee upon a contract that creditors shall not act upon it until another person has joined in it as co-surety. Guarantee is not other persons does not join. Right there. 145. I think 145, 144 I have not seen. Let me show you 144. Maybe I missed that one. 144. This is 144. Maybe it is 144 now, and 143 I missed to show 143 as well, I think. I missed that one as well. Sorry for that. And I will now 143 as well. So 143, 144, and 145. Now 145 is very simple. 145 says implied promise to indemnify surety, implied promise to identify surety, IMPLID, implied promise to identify surety in every contract of guarantee. There is an implied promise, implied IMPLID, implied promise by principal debtor to indemnify surety, and surety is entitled to recover from principal debtor whatever sum he has rightfully paid under principal debtor, whether sum is guarantees, sum he has rightfully paid under lines, but no sum which he has paid wrongfully. So this is that 145. 145 is the implied promise to indemnify surety. Oh, fuck off, bloody fool. Yeah. Implied promise to indemnify surety in every contract of guarantee. There is an implied promise by principal debtor to indemnify surety, and surety is entitled to recover from principal debtor whatever sum he has rightfully paid under guarantee, but no sum which he has paid wrongfully. Then it is 146. 146, which is co-surety is liable to contribute equally. Co-surety is liable to contribute equally. Let us say co-surety is sorry. 146. Co-surety is liable to contribute equally when two or more persons are co-sureties for same debt or duty, either jointly or severally, and whether under same or different contracts, and whether with or without knowledge of each other. Co-sureties, in absence of any contract to contrary, are liable as between themselves to pay each an equal share of a whole debt or of debt. Okay, by difficult to read like that. It's very small of this 146, and I have it here only. I can't read all that. 146, I read from here. So 146 it is 146. Yeah, it's better here below. Co-surety is liable to contribute equally where two or more persons are co-sureties for same debt or duty, either jointly or severally, and whether under same or different contracts, and whether with or without knowledge of each other. Co-sureties, in absence of any contract to contrary, are liable as between themselves to pay each an equal share of whole debt or of that part of it which remains unpaid by principal debtor. Alright, 146, 147, 147. Liabilities of co-sureties bound in different sums. Liability of co-sureties bound in different sums. Co-sureties who are bound in different sums are liable to pay equally as far as limits of their respective obligations permit. That is again, liability of co-sureties bound in different sums. Co-sureties who are bound in different sums are liable to pay equally as far as limit of their respective obligations permit. Then it is 148. Now this is chapter 9, bailment. Chapter 9 of bailment. And bailment, bailer or bailee defined. Bailment, bailer and bailee. And before this, I'll give you this. This also this. Before that, I missed this one. 147 to show you 147, which is here. 146, 147. Just like I read for you. 147, that is liability of co-sureties, and that's here. Liability of co-sureties. 147. Now I'll move to other one, that is still 5-10 minutes more I have. So let's go to same chapter now, chapter 9, that's bailment, and that is bailment, bailer and bailee defined. Part 148, bailment, B-A-I-L-M-E-T, bailment, and that is here, 148. 148, bailment, bailer and bailee defined, and this is a, you may say, bailment, bailer and bailee. Bailer, bailee, bailment. Delivery of goods. It's regarding goods. So it's regarding good event. I think you understand well. 48. This is bailment, bailer and bailee defined. Bailment is delivery of goods. Bailment is delivery of goods by one person to another for some purpose, upon a contract that they shall, when purpose is accomplished, be returned or otherwise disposed of according to directions of person delivering them. Person delivering goods is called bailer. Person to whom they are delivered is called bailee. Bailer and bailee. Person delivering goods is called bailer, and person to whom these goods are delivered is called bailee. Explanation is, if a person already in possession of goods of another person, another contracts to hold them as bailee, thereby becomes bailee, and owner becomes bailer of such goods, although they may not have been delivered by way of bailment. 149, delivery of bailee, how made. 149, delivery of bailee, how made, and that's also important. Delivery of bailee, how made. And it is delivery of bailee, how made. Let's say delivery of bailee, how made. What's happening? Why it's jumping? Why it was jumping? I don't know. Why I'm jumping? 149, it says delivery of bailee, how made. Delivery to bailee, how made. Delivery to bailee may be made by doing anything which has effect of putting goods in possession. Delivery to bailee, how made. Delivery to bailee may be made by doing anything which has effect of putting goods in position of intended bailey or any person authorized to hold them in his behalf. In a delivery to bailey, how made? Delivery to bailey may be made by doing anything which has effect of putting goods in possession of intended bailey or of any person authorized to hold them in behalf. Now 150, bailor's duty to disclose fault in good bail. Bailor's duty. So what is that? Let us say 150. 150. Bailor's duty to disclose fault in goods. Bailor's duty to disclose faults in goods. What is bailor's duty to disclose fault in this? Almost time. I have a few minutes only. Bailor's duty to disclose fault in goods. Bailor's duty to disclose faults is bound to disclose to bailey. Bailor's duty to disclose fault in goods bailed. Bailor is bound to disclose to bailey the faults of goods bailed, if which bailor is aware of and which materially okay, it's not complete anyway. Then it is then materially interfere with use of them or express bailey to extraordinary risks, and if he does not make such disclosure, he is responsible for damage arising to bailey directly from such faults. If goods are bailed for hire, bailor is responsible for such damage, whether he was or was not aware of existence of such faults in goods bailed. So this is a provision, and then they go to 151. Care to be taken by bailey. That's 151. Care to be taken by bailey. Care to be taken by bailey. Care to be taken by in all cases of bailment. Bailey is bound to take as much care of goods bailed to him as a man of ordinary prudence would, under similar circumstances, take of his own goods of same bulk, quality and value as goods bailed. 152. Bailey when not liable for losses. Bailey when not liable for losses. Bailey when not liable for losses of thing bailed. Bailey, in absence of any special contract, is not responsible for loss, destruction or deterioration of thing bailed if he has taken amount of care of it described in that section 151. Now 153, termination of bailment by Bailey's Act. Termination of bailment by Bailey's Act. 153. Termination of bailment by Bailey's Act inconsistent with condition. A contract of bailment is avoidable at option of bailor if Bailey does any add with regard to goods bailed. Inconsistent with condition of bailment. All right. Then we'll go to, like you say, inconsistent with bailment. It says horse in his carriage. No, leave it now. 154. Liability of Billy making unauthorized use of goods built. Liability of Billy making unauthorized goods built. I'm not sure करूँ कि नहीं हाँ ऐसा करने का problem. Liability of Billy making unauthorized use of goods built. That's 140.54, and this is if Bailey makes any use of goods built which is not according to conditions of bailment, he is liable to make compensation to bailer for any damage arising to goods from or during such use of them. And then it is, after all this is after us, this is 155. Effect of mixture with bailer's consent of his goods with bailer. Effect of mixture with bailer's consent of his goods with Bailey's. If Bailey with consent of bailer mixes goods of bailers with his own goods, bailer and Bailey shall have an interest in proportion to their respective shares in mixture thus produced. 156. Effect of mixture without bailer's consent when goods can be separated. Effect is 156. Effect of mixture without bailer's consent when goods can be separated. If Bailey's without consent of bailer mixes goods of bailer with his own goods, and goods can be separated or divided, property in goods remains in parties respectively, but Bailey is bound to bear expense of separation and division, and any damage arising from that mixture. So this was our 156 is plus 156. After that is a 157. Effect of mixture without bailer's consent when goods cannot be separated. 157. This is effect of mixture without bailer's consent when goods cannot be separated. If Bailey without consent of bailer mixes goods of bailer with his own goods in such a manner that it is impossible to separate goods built from other goods and deliver them back, bailer is entitled to be compensated by Bailey for loss of goods. Then repayment by bailer of necessary expenses. 158. 158 it is. This is, repayment by bailer of necessary expenses whereby condition of bailment goods are to be kept or to be carried or to have work done upon them by bailee for bailer, and bailee is to receive no remuneration. Bailer shall repay to bailee necessary expenses incurred by him for purpose of bailment. 159 restoration of goods lent gratuitously. Restoration of goods 159. Restorations of goods lent gratuitously. Restoration of goods lent gratuitously. Lender of a thing for use may at any time require its return if loan was gratuitous, even though he lent it for a specified time or purpose. But if on faith of such loan made for a specified time or purpose, borrower has acted in such a manner that return of things things lent before time agreed upon would cause him loss exceeding benefit actually derived by him from loan. Lender must lender must if a compels 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 return indemnity borrower for amount in which loss will occur occasion exceeding any benefits so derived. This is 159. And then 160, return of goods built on expiration of time or accomplishment of purpose, and this is 160. So return of goods built on expiration of time or accomplishment of purpose, it is duty of bailee to return or delivers according to bailor's directions goods bailed without demand as soon as time for which they were bailed has without demand has expired, or purpose for which they were bailed has been accomplished. After that, it is then bill is 161. 161 is there, and I don't know how many pages are there in that. Now purpose of this I cannot tell all here today. Let us now say what purpose of this is actually. This is Indian Contract Act. I was talking to you. This is text from this Indian contract, essentially for all those who deal in contracts. These contracts are based on this Indian Contract Act to an extent. Actually, this is not an Indian. This is 1857 Act, and this is British Act. You may say indirectly, nothing major change. Contract is contract. We have to understand contract. That's very important. And if you don't understand contract, you lose a lot, because you sign something which you don't understand, and later on you are trapped in by some people. And contract disputes of contracts are many. You might have seen contract goes in billions, sometimes it goes in crores and billions, and all over the world it goes like that. But essence of contract is same. It will be here or somewhere else, it's not different. We must understand the point. Its essence of contract is same, means there are two parties. In fact, we supply contractors, works contract, or whatever, employment contract or service contract or whatever it is, essence is same. Party 1 and party 2, both parties have to agree for something with free will, free mind, fully understanding what contract is. With no misrepresentation. You should adequate age as above it. It's a major one. Your mind should be free. Your mind should be sound. It should not be unsound mind. Means you can think very well, but you're signing on, and that is very important. And you must understand all conditions. You cannot freely sign some contract. Even if you freely sign, you're bound by that. So something which is not logical cannot be a part of contract. Something which is logical should be a part of it. Unnatural is not accepted. Something is workable, it should perform, it should be implemented. If it cannot be implemented, it's barred by law, then that cannot be a part of contract. So there are conditions which you must fulfill. You should understand what you're signing in. It's not simply signing. I've signed, you got a contract. There is any condition you can't comply with, or there can be any condition that can catch your hold of. And remember, even if some is preferably you are not aware of that, you cannot say out of that, because if you have been misrepresented by, if somebody has cheated you, somebody has defied you, played fraud with you, then you have to bring the notice. I could not understand why this contract clause has been added. I don't understand that. Means you can talk to them, but it is impossible to take out. Or if both parties agree to take out certain sections out of that, you can take out. That's called novation or revision, alteration of that, which we'll discuss later. Because novation and substitution or alteration or amendment, or whatever you could call them, these are very, very important points in contract language. Contract world is very different, where very expressive people are there. Contract may be simple in look, but it's very complicated sometimes, because all disputes arise on contracts, and loopholes are known to contractors and to both who design these contracts. The question is, all or whatever clause you add into them must be under certain law, under admissibility of certain law. And even why I am trying to tell you all this, because I will later on discuss about the FIDIC, which is International Standards Forms of Contract. And our profession of construction or real estate or whatever is that, whatever construction we do, industrial construction or construction, somehow some contracts of course do generate, without which you cannot move. And if you want to understand those contracts, we must be first having an understanding of basic contract, which it is contract. And according to this contract, or whatever contract, whichever country you use, FIDIC or use NEC or whatever there are so many types of different proformas. Those are supporting proformas. You have to use them if you wish, but there's no mandate on that, there's no compulsion on that. You can devise your own, but you have to follow these principles which are given in our contract act or whatever other countries contract act. You have to follow them, and simultaneously you have to use arbitration and conciliation act to be a separate one in the same contract. Both have to move together, because generally commercial contracts do not permit you to go to court directly for purpose of resolution of mechanism, for purpose of dispute resolution mechanism. Generally arbitration is that form is a statutory one, which is a mandatory, means it's like a court, whichever award comes from arbitration, that's like a court award. And so there's no major issue, but the question is, if you do not understand this is basic law. That's why I'm stressing on this, to explain to you as much as possible, because generally engineers are not very clear about this, and many more professionals are also not clear about this. That is so I want to make it clear. I'll take you next time tomorrow. We complete this one and further talk on something else, and that's all it is. Thank you very much, gentlemen. Bye.